Okay, folks, we are still on Notes 5 partnerships. We are now in part 2 because of the technological ineptness of your professor who touched the keyboard and shut the video off in mid-sentence. And just a word giving proper credits where they are due here. The creature you see pacing back and forth behind me is our family hound. Her name is Fiona. She's a very wonderful dog, good watchdog. Very protective of our grandchildren, but at the same time, very calm, very gentle. As you can see, she was getting bored with life, and it's a little bit past noontime, and so she's kind of pacing back and forth from the dining room into the kitchen, hoping that somebody will feed her. We got her as a rescue dog, and we have looked into her background. We've gone online trying to figure out what she is, and we believe she's half German Shepherd and half Ridgeback, South African. Rhodesian Ridgeback Hound. And she's a very interesting character. She has the face of a German Shepherd, but she has the very long running legs of an arched back and spine of a greyhound or a running dog. And she is fast. When she wants to run, she can run as fast as any. So if you see her walking back and forth, and if you happen to meet her ever, tell her I gave her credit as being part of your video here. All right. We were talking about, I was just finishing up on the duties and liability of partners, section 1, the fiduciary duties of partners. Now, moving on. Authority. Each partner has the authority and the duty to carry on business on behalf of the partnership. Each partner can bind the partnership in contract and in tort. They all have implied authority and apparent authority just by virtue of the fact that they are partners. So again, this reinforces a concept I've said a couple of times now in this lecture, that every partner is an agent by definition of the partnership. They can go out and make agreements, they can bind the partnership, they can create torts that the partnership will become responsible for. Now, liabilities. Liabilities in partnerships can be very tricky and very dangerous. The basic rule is that every partner is liable for all the debts contracted for the partnership and for all the tort liability of the partnership. Now, at common law, we said this was a joint liability. There was no such thing as a partnership itself in the courts. You had to sue every partner, and you had to get good service on every partner and bring them all into the court case, or you couldn't sue any of them. Under the Uniform Partnership Act, liability is joint and several, and we discussed that, saying that several means if you have 5 partners and you can only find 3, you can sue those 3 right now and then sue the other 2 later on. If you don't get full judgment from the 3, you can sue any one and get full judgment from the 1. So it is very easy, it is very difficult in this day and age for partners to shelter themselves from liability of partnership acts and partnership contracts and from the tortious activities of the other partners. If a creditor only sues 2 out of the 5 partners and recovers the entire judgment from the 2, there is something called indemnification. And indemnification means that you have paid the debts of another and you have the right to be compensated. So if 2 partners get sued and end up paying a judgment that was a partnership judgment, or all 5 should have participated, the plaintiff in that case against the partnership has every right under present law to go against the 2 partners. However, once they have been sued and lost and have had to pay, they can now bring an indemnification action against the other 3 partners and say, wait a minute, this was a partnership debt, this was a partnership loss, you guys have to chip in your share of this according to whatever your share is under the partnership agreement. Now, one of the difficulties here is what happens with new partners. If you bring in a new partner, are they suddenly liable for 40 years worth of contracts and obligations and torts of the other partners. And the general rule under the Uniform Partnership Act is that no, a new partner is not liable for events occurring prior to their joining the partnership. So that if you go to enter into an ongoing partnership and a suit comes up that has to do with something that happened 5 years ago before you became a partner, then in most likelihood today in most states, you would not have to be joined in the case. You would not be responsible for contribution to that. A partner who alone commits a tort. A partner goes out at lunch, has too many drinks at a business meeting for the partnership, and on their way back to the office gets in a car accident. The plaintiff's attorneys find out that the partnership was at a luncheon for the partnership business and sues the entire partnership because that was an individual tort by one partner. He alone or she alone was responsible for drinking, getting themselves drunk, and causing the car accident. Even though the partnership as a whole and all the partners can be found liable and have to pay, that one partner can be subject to indemnification, where the other partners can turn around and say, we did nothing wrong. You were the wrongfully acting partner. You breached your fiduciary and agent duties and partnership duties to us. We are now suing you to pay up what we or what the partnership had to pay for the losses that you created. Okay, disassociation of a partner or the withdrawal from partnership by a partner. Disassociation is a term that the Uniform Partnership Act applies to the situation where a partner ceases to be associated in carrying on the partnership business. Once this happens, the partner no longer has any ability to act. All of the partner's interests should be bought out by the remaining partners so that there is no equity, nothing should be or legally can be owned by the partner who leaves. All right? Under the Uniform Partnership Act, disassociation does not terminate the partnership. Now, this is a dramatic departure from the common law. At common law, a partnership was made up of a certain group of individuals, and if any one of those individuals died, became incompetent, or just left, refused anymore to be part of the partnership, then it was said under common law that the partnership dissolved, was terminated. And there would have to be an accounting of the books, there would have to be a payout of any interests that were held, and the remaining parties, they could go on and form a new partnership if they desired, but there was no such thing as carrying on the older partnership and taking... somehow just saying, all right, there are 5 of us, Louise is leaving, but the 4 of us are just going to carry on and still be the ABC partnership. At common law, that was legally impossible to do. Under the Uniform Partnership Act, realizing that under modern day reality, partners will come and go, people will go in and out of situations, they don't sign on to these things for life, which is in many partnerships, when you go back particularly to 17th, 18th, and 19th century England, very often partnerships were for the working life of an individual. Lawyers or doctors or accountants would form partnerships, bankers would form partnerships, and they would basically remain in that situation for their entire career. That does not happen today. And recognizing the reality today that people move around and change a lot, under the Uniform Partnership Act, you can now disassociate. One partner can withdraw, or a couple of partners can withdraw, and the others will continue on carrying on the partnership. They don't have to terminate. They don't have to get new tax ID numbers. They don't have to get new bank account numbers. They don't have to do new filings with whatever authorities or licensing agencies they deal with. They can continue to go forward. Now, disassociation occurs in several ways. One is just a voluntary withdrawal. A partner or partners say, we've had it, we don't want to do this anymore, we want out. So that would be a voluntary withdrawal. If the partnership agreement has certain conditions in it, certain terms in it, if you do not participate, if you do not actively work at the partnership for 150 days a year, you'll no longer be a partner. If you move out of a certain geographic area and therefore make yourself unavailable to do partnership work, you will no longer be a partner. So in the agreement, if the parties thought about things in advance, they can decide that if certain conditions are met, there will be triggers that say, all right, you didn't do this or you did do this, so therefore you're now no longer a partner. A unanimous vote of the remaining partners can disassociate a partner. So the rest of the partnership can decide that we're sick of dealing with him or we're sick of dealing with her, this is not working, and they can basically vote you out. Now, they still would have to do an accounting and give you your share of profits up to that point, anything that was due to you. And if there were assets of the partnership, whatever your share under the partnership agreement of those assets would be, they would have to compensate you for those. They would basically have to buy out those assets from you. A court order. If the partners end up in court suing each other, then a court can order that one or more of them disassociate without dissolving the entire partnership. And then certain things by operation of law, if a partner declares bankruptcy, a partner becomes incapacitated mentally or physically to the point they can no longer participate, or a partner dies, then automatically they have disassociated from the partnership, and the partnership can carry on, but there will have to be an accounting to the heirs, to that person, to the bankruptcy court of the partner's interests, and that will have to be liquidated and provided for, taken care of, but then the partnership can go on. If the partnership agreement specifically prohibits disassociation, then a partner who disassociates voluntarily may be liable for whatever damages are incurred, whatever costs and expenses the partnership has to incur or does incur because of this person's leaving. So just be aware of that they can't stop you from leaving, but it could become a very expensive thing if they were relying upon your skill and your expertise to do certain things, to be available at certain times, and now they have to go out and pay somebody to cover that situation. You may be at a financial loss, or you may be responsible for the costs incurred by the other partners. Okay. Upon disassociation, we had said previously, all the rights and duties of the disassociated partner cease. All right. And they have the right to be bought out for whatever equity they have in the corporation, and they have the right to an accounting and to be paid whatever profits are due to them up to the point. And under the Uniform Partnership Act, a disassociated partner for up to 2 years could remain liable to third parties for any activities that occurred while they were still a partner. So just because you disassociate from the partnership doesn't mean you're freeing yourself from any liabilities, tort or contract, that came up while you were a partner, but there is a 2-year statute of limitation on that. So if they don't bring a suit against you within 2 years, you're out from under that. Now, termination of partnerships. Partnerships can be terminated several ways, almost like dissolution. It can be by agreement. It can be because the partnership was for a set purpose. Let's build a house and sell it, and now that purpose is completed. It can be for a fixed term. We'll agree to enter into a partnership for 4 years. At the end of the 4 years, if they don't re-up, if they don't sign an extension, the partnership is over. It can be dissolved by operation of law, just as we had said for disassociation, bankruptcy, incapacity, or death. Would, by operation of law, can terminate a partnership, and it can be by judicial decree. If the partners are suing each other and the judge decides that this is a hopeless situation, it cannot possibly be preserved, a court can dissolve it. Also, if a partnership is insolvent, the partnership can be brought into what's called receivership, which is really a form of state law bankruptcy for business entities. And as part of the receivership, the end of the receivership could be that the judge, after paying debtors whatever assets are left,